Turkish ship arrest rules. The arrest of vessels in Turkey is mainly governed by the provision of the Turkish Commercial Code, which entered into force on 1 July 2012 (TCC). During the preparatory work, the drafting committee of the TCC had taken into account the provision of the International Convention on the Arrest of Ships 1999. Although Turkey had not ratified the 1999 convention at that time, as a result, the arrest of the regime under the TCC reflect the provision of the 1999 convention. Following the entry into force of the TCC, Turkey has also ratified the 1999 Convention as well as the International Convention on Maritime Liens and Mortgage 1993. Jurisdiction for the arrest. The TCC provides for specific rules of jurisdiction for arrest. Accordingly, the court at the port of call or place of anchorage or berthing or mooring or dry docking shall have exclusive jurisdiction to hear arrest application. For Turkish flag vessels, the court at the place of registry of the vessel shall also have jurisdiction. This provision will prevent claimants from making arrest application to court of their choosing in advance of the vessel's arrival. Claims in respect of which a ship may be arrested. A ship may only be arrested in respect of a closed list of 22 maritime claims which are enumerated exhaustively under TCC. Maritime claims in respect of which a ship may be arrested under the TCC as follows. A. Loss or damage caused by the operation of the ship. B. Loss of life or personal injury. C. Salvage. D. Damage or threat of damage to environment. E. Wreck removal. F. Any agreement relating to the use or hire of the ship. G. Any agreement relating to the carriage of goods or passengers. H. Loss of or damage to or in connection with goods carried on board the ship. I. General average. G. Towage. K. Pilotage. L. Goods, materials, provisions, bunkers, equipment, including container, supplied or services rendered. M. Construction, reconstruction, repair, converting or equipping of the ship. N. Port, canal, dock, harbor, and other waterway dues and charges. O. Crew wakes. P. Disbursement incurred on behalf of the ship or its owners, including the loans obtained for the vessel. Q. Insurance premium. R. Any commission, brokerage or agency fees. S. Any dispute as to ownership or possession of the ship. T. Any dispute between co-owners of the ship as to the employment or earning of the ship. U. A mortgage or a hypothecary or a charge of the same nature on the ship. V. Any dispute arising out of a contract for the sale of the ship. The above list is the same as the maritime claims listed in Article 1 of the International Convention on the Arrest of Ships 1999. The only difference is related to Art 1P of the Convention. According to Art P, refers to claim arising out of disbursement incurred on behalf of the ship or its owners, whereas the TCC specifically provide that loans obtained for the vessel will also be covered thereunder. Ship that may be arrested. The ship against which the maritime claim arises may be arrested on the condition that the owner of the ship is the debtor, By the term owner, the registered owner should be understood. In contrast to the 1999 Convention, the TCC doesn't permit the arrest of the ship for the debt of the demised charterer or any other charterer or manager on the ground that under Turkish law a judgment in respect of that claim cannot be enforced against a ship which is not owned by the person liable for that claim. If the claim is secured by a maritime lien or a mortgage or a charge of the same nature, or if the claim relates to the ownership or possession of the ship, the arrest of the ship shall be permissible even if the owner isn't personally liable for the debt. In addition to the ship against which the maritime claim arises, sister ship may also be arrested under the TCC. The provision of the TCC in relation to the arrest of sister ship are similar to the condition provided under Article 3.2 of the 1999 Convention. Counter-security. Regardless of the claim amount, a fixed counter-security of 10,000 SDR has to be lodged before the court along with the arrest application. The counter-security may be increased or decreased by the court at a later stage upon the application of the parties. Procedure for arrest. The application for arrest must be filed before the competent court with jurisdiction for arrest. The claimant must present document evidencing a possible maritime claim and the amount of the claim, and must be lodged the counter-security along with application. The court can give an arrest order based on the ex parte application of the claimant without service of the application to the opponent. Once granted, the claimant must apply to the competent bailiff within 3 working days as from the date of the arrest order, failing which the arrest shall automatically become invalid. The arrest order is enforced by the bailiff office immediately upon the application of the claimant. Action in merits. Under the TCC, the action in merits has to be filed within 1 month before the court or arbitration tribunal that has jurisdiction in merits. In addition to the other rules for jurisdiction, the TCC explicitly provides that the arrest itself confers international jurisdiction to the Turkish court which has given the arrest order to hear the action in merit of the claim. Action in merit. The vessel may be released by putting up a security covering the claim amount, interest accrued, and costs. The security may be in the form of cash or bank letter of guarantee. In the event that the parties agree on another form of security such as a P&I letter, that may be possible as well. It is also possible to file an objection against the arrest if the arrest order is given based on the ex parte application of the arrestor. The objection may be filed either before the court that has given the arrest order, or if an action in merit has been filed before a Turkish court, before that court. If the action in merit is filed before an arbitral tribunal or a foreign court, the objection may be filed before the court that has granted the arrest order. This article aims to provide a brief and general overview of the Turkish arrest rules, but doesn't intend it to serve as a legal advice. Before taking any action or relying on the information given, addressers of this article should seek specific advice on the matters which concern them. The objection may be filed either before the court that has given the arrest order, or if an action in merit has been filed before a Turkish court, before that court. It is also possible to file an objection against the arrest if the arrest order is given based on the ex parte application of the arrestor. in the event that the parties agree on another form of security such as a P&I letter, that may be possible as well. Thank you.